Good morning. Well, appreciate all of you, braving the weather and all that to be here, but we'll go ahead and get started. First of all, did anyone come in and did not get an outline? If not, raise your hand, and we've got some back there. Jamie has them right back there. If by chance I don't think we're going to run out, but if you don't get one, of course this presentation will be online here in a few days through Swinecast, and then also if you let me know afterwards if you didn't get one, we'll make sure you get one. Okay? All right. Well, again, it's good to be here, and we're here to talk about environmental regulations and nuisance case update. I know this is, we are recording here today, so if we have questions, I think we have it set up for a microphone to be handed out so that people listen to it online can hear it. Those of you who have heard me speak before, first of all, I'm surprised he came back, but anyway, thanks. Secondly, I like to take questions as we go. I think that's the best way to handle it. I'm not going through, regulations step by step today because we have some other things to talk about, and not a whole lot. If just a few things have changed nothing has changed in the regulations as far as how they've been written since 2016, and we'll go through that a little bit at the end. But what sometimes does change is how certain people interpret them, including the DNR, including me, etc. So I've tried to focus today, when we get into the outline, about some of the questions I've received from some of you out there about, okay, DNR is saying this, you're saying this, somebody else is saying this. Now, what is it really? What is the law? And usually I try and, you get my version of it anyway, but unfortunately I'm not king, so sometimes my version isn't the one that is followed, but we'll at least have that discussion today. So with that, we're going to start with, again, it's called an Environmental Regulations and Nuisance Case Update. I should have flipped that around because today we're going to start with nuisance cases. And your first slide there, number 2, I thought I'd start with current events. And, as an attorney, as many of you know, I and my partners I work with, and by the way, I am with the Gentry law firm now, was with Beving, Swanson, and Forrest for 20-some years, and I've been with the Gentry law firm here in Des Moines for 4 years. It's 4 years here in a couple days. But anyway, I and my partners defended a nuisance case just last week in Buchanan County. Anyone here from Buchanan County? Don't see anybody who was on the jury here, but that case, I've got it on the screen right now. It was an 800-head cattle lot. I know we're here for the pork congress, but it was a cattle yard. Concrete cattle yard with a concrete runoff basin. And it was 9 foot high. Usually only got up to about 8 foot or so, but it was just short of half an acre basin, concrete. So 136 feet by 136 feet. And again, all the cattle were on concrete, a couple sheds, 3 sheds, I believe. And the neighbors who sued, the plaintiffs, and I've got the names of the parties up there, it's public record. The neighbors, 2 houses were it was an east-west road across the blacktop to the north, and they were both about 500 feet away. I mean, directly across the road. And we'll talk about some of the factors in a nuisance case. Many of you know them, but they moved there first. They lived there, let me put it that way, first, and then a young couple bought the acreage where this cattle yard is now, and then they put in the basin, and then they contract fed cattle to Mr. Higgins there of Brayton and Higgins to feed cattle there, Holsteins, and fed around 800 head at times, often more like 500-600 head. And the Olympuses and the Fitzgeralds filed a nuisance lawsuit, and somebody was giving me a hard time. This lawsuit was filed in 2014, so it took almost 5 years to get to court. Part of the delay, and it wasn't all me as an attorney just trying to drag it out to get more fees, I assure you. Right? Curtis, you were going to say that, weren't you?
I was going to let you know about it.
You already did. Anyway, part of the delay is a case we're going to talk about here in a little bit that went to the Supreme Court on the nuisance defense, and whether it was constitutional or not, the Hanna-Michael case, and that delayed this case and many other nuisance lawsuits in Iowa. They were pretty much, all the judges put them on hold until that case was decided by the Iowa Supreme Court, and that delayed it over 2 years. So only 3 years of that delay is mine, I guess. Anyway, went to the jury, 8-member jury, Buchanan County, started on January 9th. And the jury, we took a day off last week ago today. The judge had another matter to attend to. The jury then heard closing arguments on Thursday, and that afternoon ruled no nuisance. They found that the plaintiffs had failed to prove that there was a nuisance. Much of the testimony, and again, I'd probably tell you about it if we had lost, but I may not go into the detail. I'm going here since we were able to win. But I know you as producers, again, that was a cattle yard, but we're all livestock producers, and we don't hear about cases in the media, do we, when we win? And we're going to talk about some more of those cases, and then the North Carolina cases. And how many have heard about the North Carolina cases? Okay, almost everyone. The multi-million-dollar verdicts, etc. But the media doesn't seem to want to give any press to the cases where we get what we lawyers call a defense verdict, or where the livestock operation prevails. And we have a few of those, not just that one, but others, and I'll talk about those. Anyway, the jury, again, ruled that it was not a nuisance, heard testimony from all the witnesses, including witnesses who were tenants. There was a house right next to the feed yard. It had been a farm at one time, and then the acreage had sold off. So the owners of the feed yard fed out cattle under contract, but they rented out the house. And we had several of those folks who came forward and testified that when they lived in the house, and the current tenants and several others, and they testified, yeah, there was odor. There's 800 head of cattle right over the fence. Of course there's odor. But it wasn't anything different than living in the country. And the jury heard that testimony. Of course, the plaintiffs across the road testified that the odor was bad and it was a nuisance, and the jury found that it was not. So there are several things to learn from that, but one thing I think I would tell you folks who have hog buildings, and just always put a rental house right next to it and rent it out. Okay. See? You've never heard that before, right? As someone who has an acreage myself, I don't have a hog building on it, but rents out to tenants in the country, I'm not sure it's worth it to deal with that, but I'll leave that one alone. I've got good tenants right now in case they're listening. Okay. All right. That's the most recent case, and you can't get much more recent than last Thursday afternoon for that jury verdict. Okay? Moving on, slide 3, we had some verdicts prior to that here in Iowa. I've talked about those before. The case out of Powesheik County from 2015, where unfortunately for the livestock producer went the opposite way, 2,200 feet away, it's a north-south road. The hog operation was on the west side of the road. The residence was on the east side, so it's north-northeast, 2,200 feet, and the jury in that case found it was a nuisance and awarded, they awarded $500,000, but the judge reduced it, or $525,000. The judge reduced it due to the property value, but they awarded one person $462,500 for a nuisance. We had a case a year later then in Wapello County, the Pauls v. Warren case. I've talked about it before, February 29th of 2016, where the 9 plaintiffs, 4 residences, a little over a mile up to 2.5 miles away, and the jury in that case found no nuisance, awarded no money, and after the trial, the judge ordered some of the plaintiffs who, and I won't get into the details, but ordered them to pay not attorney's fees, but some of the litigation expenses, because the judge found their claim was frivolous. So, and you see the number there. All right? If you have any questions as we go, feel free to stop me. Okay, I talked about other cases from other states where we have had good results for livestock producers, and then I'll get to the North Carolina cases. But we had a case out of Illinois in 2016 also, two 7,500 head finishing sites. This is in, I would call it central Illinois, by just about an hour or 45 minutes west of Jacksonville, Illinois, in Scott County. And there, the jury found no nuisance for 5 residences, 10 plaintiffs, and 1 residence was, I have here, a 1/10 of a mile away. There was a 7,500 head finisher here, a 7,500 head finisher here, and for those of you listening to this tape, I'm holding my right hand up and my left hand up. They weren't very far away, and there was a plaintiff in between the 2 sites. So that's where we get the 10th, 1 household there anyway. Anyway, the jury found no nuisance in that case, and again, it comes down to testimony of others who live in the area who are willing to step forward. And when I talk to those people, because I do represent livestock producers in these cases, we emphasize to witnesses like that, people who live in the area, who are not involved in the lawsuit, you're not, in our opinion, you're not taking sides, you're just coming forward and telling the truth. They are asked, what is it like at your house? What do you experience at your house? You're not asked as a witness what it's like at anybody else's house. It's just about what people experience in the area, and I'll tell you in a minute how that's important in a case. But in that case, those people stepped forward and testified, and the jury found no nuisance. The other one I have there is in Mississippi. I guess we're getting a little ways away from home, and it was a poultry operation, a broiler. I don't know much about the case. 55 plaintiffs. That was in 2017, and again, no nuisance. And then the last one was just a little over a year ago up in Minnesota. A 3,200 head sow farm, 6 plaintiffs, 4 residences, 1/4 to a half mile away, and again a jury verdict finding no nuisance. Now, those of you who have heard about the North Carolina cases, which I'm going to cover next, how many of you had heard about any of these cases? There you go. A couple of you had, but that's just an example. Bad news travels a heck of a lot faster than good news, because these cases are just as important. Juries found no nuisance, heard the evidence of plaintiffs who were claiming it was a nuisance, they couldn't enjoy their homes, etc. And the jury heard other evidence presented, which I'm sure similar evidence has been presented in the North Carolina cases. I haven't been involved there. But the point is, these juries found no nuisance, and do we read about those in the paper? No. And I guess I can't change much about that other than to say I'm here to try and present the facts. Did I see a question? Okay. All right. Next slide. Slide 5. Here are the North Carolina cases. And the information I have up here is what I've gotten through official sources on the internet and some not so official. 3 cases. I'll leave a lot of this for your reading, but you can see the dollar amounts we're talking about. There are 26 cases scheduled for trial in North Carolina, and we've had 4 of them go to trial. A 5th one was to be going on right now, but the government shut down. These are in federal court, and I read that because of the government shutdown, the inability to make sure jurors would get paid for their time as a federal jury, the trial was postponed, continued until after the government shutdown. So here's the 4 cases we have. The bottom one is the most recent. Jury verdict just December 12th, and that's the one, the best result for the pork producer there. $102,000 in compensatory damages, no punitive damages. Working your way back up, we're talking about a lot of money here, folks, awarded by that jury, those juries for punitive damages, and then North Carolina has a law that limits punitive damages, so I have the amounts after they were reduced. That's still a lot of money in those 3 cases. All 3 cases there are on appeal, it's my understanding, and so we'll see what happens on appeal. Yes, sir.
Are the North Carolina situations all lagoon, or do we status? I mean, what's the type of operation we're talking about in North Carolina?
The question was, for those listening to this on the internet here in a few days, the question was, did all of the North Carolina cases involve lagoons, correct?
Correct.
That's my understanding. And from what I've read, that's my understanding. And I think they also involved some sort of spray irrigation. Now, I haven't been there. I haven't been part of the trials. I don't know, but that's my understanding. And I have, there has been some discussion that I've seen on the internet again. Of course, everything you read on the internet is true. But that, you know, there's some question about, you know, does there need to be a change in regulation? Again, I'm just speaking about what I read, you know, about that type of manure application. Most of you, if you're not from Iowa, you're from the Midwest. I know not all of you are. I think we apply manure a little differently here. Not saying it's better, not saying it's worse, but we usually inject. And I think we all understand. It's just a different system there. I've never been to North Carolina, and many of you have, so you'd have to tell me how it is. But that has, in my understanding, that has been a common thread through all these cases in North Carolina, is the method of manure application. I saw a hand back there.
Do they have different right to farm laws than we do here?
The question was, do they have a right to farm law like we do here? Yes, they do, and it is even, I don't have it in my slides, and I don't know, I don't think it has been able to be applied in these cases because when the cases were filed, it's my understanding they were filed before it went into effect. I don't pretend to be an expert on North Carolina's right to farm law. I have enough trouble keeping up with our own, but it's my understanding they do, but it hasn't been able to be used in these cases. Any other questions? Yes, sir.
Yes, about cases that you know of. What is it costing the owner to protect himself? In other words, are you insured?
I hate that question.
Or, no, you don't have big
Next question, please. I'm sorry, I didn't mean to interrupt you, Don.
Saying sometimes we need nuisance insurance, and if it isn't in there, their insurance don't cover you. Are they finding that they are covering them or not? Or?
Boy, you packed a lot into that one question there, Don. But okay, I'll repeat the question. First of all, your question is, what does it? You saw me swallow hard there, didn't you? The question is, what does it cost to defend these for the producer, right?
Right.
Secondly, you ask if their insurance covered it. Does that cover your question? Okay, first of all, nuisance cases are very expensive to defend. See that? Anyway, I'm sorry, I shouldn't joke about this. I would say most nuisance, I don't know what those North Carolina cases cost. There's been some, I'm not going to get into that. The cases I know of in Iowa, you're looking at legal fees usually to defend a case somewhere between 20 to, I'll give you quite a range, $20 to $80,000 just to defend them. You people enjoy seeing a lawyer squirm, don't you? All right. Because they are expensive, and that includes not only legal fees, expert witness fees, etc. And another cost, and I don't mean to, I'll get back to the other part of your question. Actually, I have a slide on that, so I'll probably move to the slide and then we'll talk about that. The real cost I see for producers, and not the real cost, the money, of course, is the most important part, but the time it takes away from your business to deal with that, and the emotional toll to deal with it. And, you know, a lot of people, I bet if you ask some of these people who have won, they'll still say, I feel like I lost because of all the time it took, and even if they had insurance to pay their legal fees, it still is a real drain on them, and I know we get accused of dragging, we being lawyers, dragging things out, but they usually take at least a couple years before they go to trial. It is a real strain on the operation. But anyway, did I answer your question?
Pretty much. That always strain of neighbor relations that you lost when you file that way.
Yes.
Hard to build it across the back.
And I'll repeat that because it's a good point. The neighbor relations part of it, nuisance suits are between neighbors, and that probably, once you go through a nuisance lawsuit, most of that destroys any neighbor relations that were there. And I'm not, I think there's blame on both sides there, but I represent producers, and Often there is something that occurred before the lawsuit. I'm not saying in every case, but often there's something that happened a few years back where there's already maybe a little bit, somewhat of a conflict occurring. Not always, but in many of the cases. And it's hard on everybody. The producer will say, well, I didn't file the lawsuit. They did. The neighbors, and being as fair as I can, even though I represent producers, the neighbors would say, well, you're the one who built the building there. But it is a strain on everyone. Okay. You're welcome.
Eldon,
Yes, sir.
you mentioned a fee for expert witnesses.
Yes. And I'll repeat your question. Go ahead.
How many of the cases, I know we hear about in the North Carolina cases, they didn't allow certain testimony that would have been of value to the producer. There are olfactory models out there that can determine scientifically nuisance, no nuisance. Is that a factor for some of these cases?
Okay, the question, and I'll summarize it as best I can for those listening on the internet, was regarding expert witnesses and regarding experts that evaluate odor. And can that be presented as testimony if they evaluate the odor and give it we have what's called the nasal ranger. We have field olfactometers that do measure odor, but they all depend on the human nose. We don't have any way to measure odor. We can measure gases, but we can't measure odor itself without the human nose and the assistance of some type of, like a nasal ranger or the field olfactometer, which, or the laboratory one that uses a panel. Anyway, that evidence, in cases I've been involved in, will be admitted through if the expert is qualified, and there are several that have used that. As far as the cases, I don't know if that's been used in North Carolina. The cases I just talked about here, let me go backwards here. For instance, these cases on slide 3, the McElrath case, I believe some monitoring was done. I believe some, I wasn't involved in that, but I believe some was presented. The Pauls v. Warren case in Wapello County, I don't believe any monitoring was done. They had expert witnesses, but I don't believe any odor monitoring was done. The one back here, the one on slide 2 from Buchanan County, an expert testified for the defense, and I should say most of the time, and I've got a slide on that coming up, most of the time both plaintiffs and defendants will have experts, in some cases not. Here in this case in Buchanan County, it involved flies as a nuisance also, claim of flies, and that was probably, there was as much evidence about flies as there was odor. The plaintiffs had a fly expert testify that, in his opinion, the flies were a nuisance based on what he saw. He never visited the site, but he looked at photos, etc. The defendants in that case had no experts. Well, not on flies. I'm trying to say this correctly. There was one expert who testified about odor, didn't do any monitoring, and did testify in his experience that the flies were not a nuisance either. So we had one expert on the defense and one on the plaintiffs. Okay, long answer to maybe a short question. If I can summarize and make sure I've answered your question, experts are often involved, and if the experts are related to odor or flies or even management of the operation, well, I've got a slide. Let's talk about it there, because, and that's fine. I don't mind getting ahead of myself, but I'll make sure I don't miss anything. I'll come right back to that. Here's what's coming up, slide 6. And there's no, these are the cases I know of that are pending, and some scheduled for trial. There may be cases out there I don't know about. If you know of any, let me know. It's my job on behalf of the Iowa Pork Producers Association to try and keep track of these. There's no central place where you can type in nuisance Iowa District Court and find these cases. It's pretty much, they are online, but you have to know what you're looking for or know about them. We have one coming up. Starts a week from yesterday in Henry County, Mount Pleasant, Iowa. It's against several swine finishing operations. Jefferson County, there's one scheduled for June 18th. Des Moines County, again, these are all swine. As you can see, I've got the counties listed. The people's names are public record, but I found over the years I don't use people's names in the presentation I give anyway, even though they're public record, who the parties are, until there's a decision, and then I will put those names out there. Otherwise, I just feel that, until a case goes to trial, let me put it this way, just about anybody can file a case if you really want to, and I don't feel it's fair to the producer to talk about names, at least in my presentations, until we actually have a decision. Okay, you see the other cases out there that stretch into 2020. Again, we have 8 on file that I know of. That number's been pretty constant the last 4, 5, 6 years, something like that. So if you have any questions about any of those individually, see me afterwards, and I'll be glad to tell you what I know, which is of record. Okay, here's where slide 7, I wanted to get in some of the details, like the gentleman asked me here about experts. These cases, starting at the top there, the ag nuisance cases, odor and flies, that's the primary claims. Actually, the case out of Minnesota I talked about, there was a claim of light, a nuisance from the lights at the operation. Now, I don't believe that even made it to the jury, if I remember right, but that's pretty unusual. Sometimes you'll hear complaints about dust from the truck traffic, but usually that doesn't get brought up at trial as a claim. It's just usually odor and flies, and primarily odor for hog operations. What is a nuisance? Unreasonable interference with the use and enjoyment of property. We have what we call the normal person standard, and for those in defending a nuisance lawsuit, this is extremely important. The next, I'll come back to that. The next factor, who was first, that's also a very important factor. I've been doing this, 25 years now or whatever. I've been working on these cases. I've had one, and out of whatever I've worked on, I'm not tooting my own horn, but it's been quite a few. I've had one where the hog operation was first, okay? Or the livestock operation, that was hogs. One. The rest of them, the neighbors were there, and the operation was either built or expanded, and after the neighbors were there. Most of the situations I know of where the operation is there first and a neighbor moves in and believes it's causing a problem, they don't get filed because it's very difficult to prevail in a case when you as a neighbor are not there first. That's a critical factor, and I just know of one, and in that case, the livestock operation won that case, and that was here in Polk County about 10 years ago. The normal person standard. What the law says, and as a jury, how many here have been on a jury? When you went into the jury room, somebody came in and explained exactly what you were supposed to do, how you were supposed to do it, and if you had any questions, they answered those questions, right? And I say that firmly with my tongue firmly in my cheek. No, that's not the way it happens. The judge reads you the jury instructions, about 20 sheets of paper, jury instructions on how you're to handle the case, and then the attorneys give you the closing argument. The plaintiff's attorney tells you why they want you to rule in their favor. The defense attorneys both attorneys summarize the evidence that's been presented, and they tell you why they want you to rule in your favor. Their favor, I should say, excuse me. Then you go into the jury room, and that's it. You are there with what you've just heard, your notes during trial. You're allowed to take notes in almost all courtrooms I know of. Didn't used to be that way. And you have the jury instructions. The reason I say that, nobody comes in and answers any questions. You are told, here, render a verdict. One of those jury instructions in a nuisance case will be the normal person standard. One of them will be who was there first and the importance of that. One will be the normal person standard, and it will say something to the effect that if a normal person living in the locality of the operation would consider this to be a nuisance, then it's a nuisance. And I'm paraphrasing. It doesn't say that exactly. It'll also say if a normal person living in the locality of the operation would not consider it a nuisance, then you are not to consider it a nuisance, even though the particular, and the word idiosyncrasies is in there, the particular idiosyncrasies, and I forget what else it says, of the plaintiff make it unendurable to him or her. So the whole point is The goal of that jury instruction, which comes from the law here in Iowa and other states, is to remove it from, well, the plaintiffs say it's terrible, the defendants say it's not. What is the normal person standard? Okay, and that is, again, someone who's considered, who doesn't have idiosyncrasies that would influence how they are smelling the odor. Okay? And there will also, in the last couple of cases I've done, there would be a jury instruction that says a plaintiff is considered to have normal sensibilities unless there has been proof otherwise. Folks, in a nuisance, this is where the defense witnesses come in, the expert witnesses, if they've done any monitoring, the witnesses I talked about, who the tenants in the house, others in the area who aren't involved in the case, their testimony is critical on both sides for whether the jury determines it to be a nuisance. Experts, I believe sir, with your question, I hope I've answered it. I mean, experts are normally admitted unless they're not qualified. I'll just tell you what one juror told me after a trial when I thought we had good experts. And I'll tell you two stories here. One on experts. Many jurors will tell you, well, they had their experts, you had your experts, you both paid them. Okay, fine. Right? They look at it as you hired the expert that was going to say what you wanted to say, the other side. And we hope that's not the case. We hope that we're hiring experts that will be fair, but that's the way some jurors look at it. The other thing I had a juror tell me, because after the case is over, you can talk to the jury. I didn't have a juror tell me this. One of the first nuisance cases I ever did, our clients ran into one of the jurors in the grocery store. Small town, didn't know the juror prior to the trial, otherwise they couldn't have been a juror, but afterwards they recognized each other, and they were talking a little bit, which was fine. And my client, I hope anyway, I think she said, well, you know, we really liked our lawyer and didn't really care for how the other lawyer handled it, and the juror said, we didn't like any of them. So you talk about something that brings you down to earth. Okay. I mean, think about it. And if you've been on a jury, you're being asked to take some of these nuisance cases, you know, forget about the North Carolina ones that last a month, but you're talking at least 4 or 5 days, more like 5 or 6, out of your life, sitting there, listen to this. I could do a full hour on jury selection, and we won't even talk about that. Anyway, moving on then, so I can get through this information. Any questions? Steps to help avoid a nuisance lawsuit. Every time I talk about this topic of nuisance cases, I feel I give so much emphasis to cases, the evidence, what the jury verdicts were. And you, again, you can ask anyone who's been through one of these cases and they won, they're still going to say, boy, I still feel like I lost. Even, you know, if I had to pay the attorney's fees or just the time it took. The whole goal is, and we all hope we can, avoid these nuisance lawsuits. And I can't give you a silver bullet. If I could, I wouldn't. I'd be making it. Well, I don't want to say it that way. Let me just say I would not be standing here. Probably, I'd be doing something else to. I'd be making $1 million, right? If I could tell you how to avoid these entirely. There isn't any one thing I can tell you. Again, I can also tell you that people who have been through these nuisance lawsuits, a lot of these things they did, and if they won or even if they lost, they still did these things. Sometimes you just have the wrong neighbors or the right ones. Location, I don't think there's any substitute for a good location. Distance, prevailing winds, topography, tree buffers. Again, I don't mean to rush through these like they aren't important. They're very important, and I think there will be there are some seminars here at the Port Congress talking about environmental practices, and I think those are very important. Building ventilation management. Again, in the interest of time, I'm probably not going to get into a lot of detail here. Mortality handling, I will tell you in front of a jury, plaintiffs' attorneys love to emphasize dead pigs and dead cattle. Every trial I've been in, I think I've had to look at a picture that the plaintiffs were able to obtain of a dead hog laying next to a dumpster waiting for the rendering truck, or a compost pile that could be seen from the road with legs sticking out, or a compost pile with the corn stalks or the other material had blown off, and they can see it. I mean, dead livestock attract the attention, and I'll tell you a quick story about the case we just went through. When you do a case like this, the jury gets, as exhibits are introduced, the jury gets to see them. We had a picture in the case I just told you about up in Buchanan County of the compost pile that didn't look very good. You could see the carcasses, and they were cattle, so they weren't little. And the jury was shown those pictures prior to our, plaintiff goes first, then us. They were shown those pictures, which was perfectly legitimate. And the reaction of some of the jurors was not very good when you look at those pictures. The point that has to be made is that's not a good management practice. We understand that. The point is we all strive, if we have a compost pile, to keep it covered. It's very hard to do sometimes, but it all comes back to odor. What was the odor from that? And the testimony from others in that trial was, well, I never smelled any dead animal odor. But again, for those of you with neighbors who might be not real happy about your operation, management of those mortalities is critical. I'm not going to tell you not to compost or not to render, etc. Just mortality handling is critical. Okay? I think anything else I'll leave. If you have questions, I'll be glad to talk to you afterwards. Insurance. That was your question. Back to this. Your standard farm liability policies do not cover nuisance cases normally. How's that for an attorney giving you a direct answer? Notice how that normally came in there? My advice to you is if you have concern about neighbors who may not be pleased with your operation, talk to your insurance carrier, tell them what kind of insurance you need. What you need is insurance that will cover both attorney's fees and a judgment if you lose in a nuisance case. And the nuisance is for odor and flies. Tell them that's what you need. Because, we attorneys, when we write something, it's easy to understand, right? You know exactly what I'm saying. Insurance policies, I can never understand what they say. And I shouldn't pick on insurance. Well, yeah, I can. Everybody picks on me as a lawyer, so I can pick on them. But make sure you're getting, if you want nuisance coverage, because it won't say nuisance in there anywhere. And there are people here at the Port Congress every year providing that coverage. Talk to them about what you're getting. Your standard farm liability policies sometimes do cover it, but most of the times don't. Yes, sir.
Some of the odor insurance that I've looked at calls the odor sudden and accidental, or it puts a number of hours on it.
Yeah?
Does that cover one of these lawsuits?
The question was, this gentleman has looked at policies that purported to be a nuisance coverage that call it has to be sudden and accidental, right? And they put a number of hours on it.
Right.
Don't know that I've seen that. It should cover. Okay, here comes the lawyer disclaimers. Okay, you ready? Should cover. How many hours did it say?
Usually 48 to 72 hours.
For the duration of what's causing the nuisance, I'd be. Pardon me, I'd be concerned about that.
Now, I've never seen an order being sudden and accidental.
Right. I would be very concerned about that because you're going to have a hard time showing that, it just comes and leaves within 48 hours. And then, now the sudden and accidental, I've seen that and I've seen coverage under that because you get into how insurance policies are written. And I know I'm waffling here, but no, I'd be very concerned about that policy. That's the short answer. And I'm sure whoever has offered that to you will probably listen to this and give me a hard time. But with those policies, one thing I like to say is talk to someone who, the agent, I know the agent is trying to sell you something, but good agents will explain if they have a track record of going through a nuisance lawsuit. That's very valuable. With that exact policy language, have they been through one? What did they cover? What didn't they? I've had companies that have provided coverage, and how can I say this? I know we attorneys are expensive, but those companies did not want to pay for as much as we felt was necessary to defend the case, experts, etc. And the other companies are fine with doing what is necessary to defend it. So it truly is an art reading through that, and you got to. The important thing is look for a track record of the company of how they've handled them. Okay? Any other questions on that? Let's talk about law. There ought to be a law, right? There ought to be a law to stop these things. Well, every state in the country has some kind of law that is a right to farm law, nuisance defense, etc. In fact, Iowa has 4, okay? And 2 of them have been found unconstitutional. So we took another shot at it, we being the powers that be a couple years ago. But let me talk about the first one. Well, not the first one. It's actually the third one, adopted in 1995, amended in 98. It's the Animal Feeding Operations Nuisance Defense. And basically it says, if the jury finds you're a nuisance, but you have complied with all applicable law and you've used generally accepted management practices and it isn't unreasonable and it's for substantial periods of time you haven't interfered with it, you get a defense. If it was a nuisance, now it's not. That law was found unconstitutional in 2004 in certain situations. In this case on slide 11, here's the case I was talking about this year, the Hanemichael case, the second bullet point down there, the yellow bullet point. After that case, decided in June of this year, that's when we got the decision, the court ruled, and we're really getting into lawyer stuff here, but I know you folks can understand it. What the court has said now is in each case where this nuisance defense is raised as a defense by the livestock operation, the plaintiffs, those bringing the lawsuit, have to prove those 3 factors. Number 1, we won't even get into that now unless you have a question, but they have to prove that their clients suffered a significant hardship and resided on their property long before the operation began and spent considerable sums of money for property improvements. That's what the Iowa Supreme Court has said. The neighbors have to prove before, and if they can't prove each one of those things, then the law is constitutional and the jury gets to decide whether you have qualify for the defense and get the defense, okay? The case we just had in Buchanan County, that's why we waited 2 years for this decision. Now, we would have preferred, and 2 justices out of the 7 on this Supreme Court case said it should be constitutional in all cases. They would have just thrown out these factors and said it's constitutional, but the other 5 said no, you have to follow these factors, okay? In that case we just got done with, the trial judge ruled that they had not proven these factors, the last 2, and therefore it was constitutional, and we got a jury instruction on it. Luckily for us, this would have helped, because if the jury would have found it a nuisance, then they would have had to decide, have we met the generally accepted management practices, etc. Here the jury found it wasn't a nuisance and they never got to this. Not exactly what we wanted from the Supreme Court in June, but it's better than what we had. Okay? Yes, sir.
Do you want to ask your question? This is a catch box. If you ask your question in it, it's like a microphone, and then you can just pass it to the next person.
Oh. Okay.
You can talk into it.
Talk into it?
All right, here we go.
Wow, okay. Back to those 3 bullet points. Do they have to hit all 3, or is it 2 out of 3 is good enough, 1 out of 3 is good enough?
And I'm sorry, they can hear the question now, right? So the plaintiffs, those bringing the lawsuit, have to prove, whoops, I need to back up. I'm looking at the wrong 3. They have to prove all 3. If they can't prove one of those 3, then they haven't met their burden. In our case, they couldn't prove 2 of them, the last 2. Okay? All right. Here's the new law that was adopted in 2017. It's not a nuisance immunity, so to speak. It's it limits the damages. If there is a nuisance, it limits the damages. And again, in the interest of time, I'll probably not go through the factors here in detail, but it is an important law. It's the fourth law passed in Iowa, you still get the first law. We didn't do away the first one I discussed today. You still get that. That is still there. This one is on top of that. Now, the case we just had, we weren't eligible to use this law because it wasn't in effect yet at the time the lawsuit was filed. When it's hanging around for 5 years, why this law was passed after the lawsuit had already been filed, so we couldn't use this. But here, it limits the damages. If you qualify for this law, any damages for decrease in the market value of the property, first they'd have to prove that, and then it's any what we call special damages. I can't sit out on my deck at night, I can't hang clothes on the line, I can't have friends over. That last bullet point for annoyance and loss of use and enjoyment, any damages there cannot exceed 1.5 times the decrease in property value. So, and I've given this example last year, I think, when I talked here and others. Say you have, pick a number, 20, say the plaintiffs can prove their property, that it was a nuisance and that their property was devalued $20,000 by that hog building being there, or that cattle building, whatever it is. So then you have 20,000, and what's 1.5 times 20,000? 30,000. Add those two together. Their damages could not exceed 30,000. The jury couldn't go above that. Okay? Missouri has a law similar to this that, again, limits damages. I think Iowa's the only one that gives a number like 1.5 times or whatever it is, but some similar laws like this limiting the damages. Okay? All right. Nuisance law. 45 minutes of it. Okay? But it is a hot topic right now, a current event. I felt it was important to take that first. Okay. And again, the rest of what I've got to say, of course, is important, but not a lot new here on the rest of it. First of all, EPA air emissions, CERCLA and EPCRA. CERCLA, Congress passed a law last spring. Last year when we were here, we were all talking about, are we going to have to file those reports, or are we not? No. CERCLA, no reports. Congress changed CERCLA law, exempts farms. Then on EPCRA, the emergency notifications, there's as many of you know, there's a proposed rule out there from EPA that would exempt us from that, and it's already been out for public comment. I can't say for sure, but it looks pretty good about it being adopted. So no reporting at this time. If I don't get beyond this for the rest of the talk, that's fine. I really want to focus on this. Remember the DNR Work Plan investigations, 5 years ago when I was here, and I've talked about it every year since. DNR's coming around, doing these inspections. They were required by federal EPA to do this under the work plan because the environmental groups challenged DNR and filed a petition with EPA saying, DNR's not doing their job, take it away from them. They're not doing their job. So over 5 years, all of you have had to go through inspections, sometimes on site, sometimes online on the computer of your operations to determine if you're discharging and would need an NPDES permit under federal law. Never mind that state law says you can't discharge if you're a confinement operation. Is my bias showing at all here? Okay. Anyway, we went through those inspections. And you folks have done a great job. Here we are. We have completed the 5th year of the work plan. 100% of the inventory that DNR had, they issued this report in August, 100% of their baseline inventory of operations have been inspected. There are 170 total active NPDES permits, and to my knowledge, not a one on a confinement operation. Okay? It's all open feedlots that have the NPDES permits. So, I better just leave it at that, okay? But here comes I'm sorry, I get to stand on my soapbox some here. About a year ago, I looked at the article again this morning, a little over, a year and a half ago. When DNR issued this report in August of 2017, DNR said there's 5,063 additional animal feeding operations out there that we didn't know about. Well, then we see this article in a certain newspaper that I won't name that said, oh my gosh, and the environmental folks were saying, oh, this is proof. DNR doesn't know what's out there, etc. DNR said there were 5,000 out there. We heard about it. Well, how come this year when this report came out and what I'm going to tell you, I never saw an article on this? Here's what this year's report from DNR said. The next, well, I have a pointer here somewhere, but I won't mess with it, where it says, as of 7/31/2018, 2,772 of those 5,063 were vetted. They had looked at them. Have any of you gotten a letter in the mail that said, we think you, in essence, it says, we think you have a confinement operation or an animal feeding operation. Please respond to us as to what it is. Anybody gotten that? All right. I have gotten calls through the associations of people who have gotten that. Sometimes it's a machine shed. Sometimes it's a hay shed. Sometimes it's a building you used to use. They're checking on this to DNR's credit. When you get those, go ahead and respond with whatever it is. But half of them roughly were vetted. 99.4% of those 2,772 are not regulated under state or federal law. So 99.4% of that one half are fine. Aren't even in this, shouldn't be in the system. Of the 18 requiring regulation, 10 were medium AFOs needing manure management plans. Some of those were probably confinements. I'm not well, they'd have to be if they needed a manure management plan. They just didn't have one. They needed one. They got one. 10 of them. 8 were large CAFOs, none of which were discharging. That's what DNR found. DNR anticipates vetting a majority of the remaining unknown facilities by the end of the year. Now, here's the further breakdown of those 2,772, and this is all in DNR's report. If you go online and type in what I had on the previous slide, you'll find all this. 1,445 were SAFOs under the 500 animal unit category, were never had to be in DNR's system, but DNR's identified them. And but again, they were in full compliance with the law, didn't have to be in the system. The medium AFOs needing an MMP we talked about, the large CAFOs, not an AFO. 134 of them weren't even an animal feeding operation. Maybe the machine shed I talked about, I don't know. And the closed AFO, I assume a cattle or hog building that is no longer being used. Again, I'd kind of like to see an article pointing out what really was found, but I'm not holding my breath. Okay. All right, enough of McAfee editorial. Okay, moving on with the time we have. And you have the slides here. Some of this is DNR regulation that questions I've gotten here in the last few years, or the last year or so. First of all, before I get that, we have a lawsuit on file. I talked, I think, a little bit about it last year. We have a group, 4 Northeast Iowa residents that have sued the DNR alleging that this law that I have on the screen that says a confinement operation shall retain all manure produced by the operation between periods of manure disposal, they are alleging that applies to whatever comes out of your ventilation fans. The law was intended, and I can say this, it's still in the courts, it's been appealed, but the law was intended, it's in the water quality section of the Iowa Code, it was intended to say you can't discharge to the water, you have to retain it. They are arguing that it means you can't have any manure components getting out of your ventilation fans, and that DNR is not properly regulating that. A Polk County judge, it was filed in Polk County because it's just challenged to a state rule or regulation, said no, it's a water quality regulation, not air quality, dismissed the lawsuit. That has now been appealed to the Iowa Supreme Court. So I don't know if we'll talk about the decision next year, but we'll keep you posted. I don't know if it'll be out by then, but we'll let you know when it comes. All right. I think I'm going to move through these next few slides. I have on, well, this one's pretty important because of a case I'm aware of. When you're siting a hog building, we know the distances, confinement building, from water sources, right? 500 feet. How does DNR regulate that? John Everly and others, Keith, you deal with it. Where'd Keith go? There he is. You deal with it in that, you got to be 500 feet away from a creek. And I'm from southern Iowa, so I can say creek. All right? And what is a creek? It's something, DNR in my experience will say, it's a ditch. Even if there's not water in it, it's something that you can't farm through with normal farming equipment. That's my understanding. Okay. One thing to keep an eye on, we had different distances as we moved through, and I have the dates there. If in this process a DNR finding some of these SAFOs that were not in their system, they have determined that some of those are too close to a water source. Make sure, if you have a client like that, or if you're one of those, make sure, look at those dates, because you may have been legal when it was built because it was 200 feet at the time. That changed. Double check those dates with DNR. The second point I'll make, if you're putting up a building and you have a ditch there that is going to be determined a water source and it's within 500 feet, some decide to make the ditch into a grass waterway, right? Do something so that it doesn't qualify with the bed and the banks and all that. Fine. I had a case here that where a producer did that partly, well, just did that. It was alleged by the federal EPA and the Army Corps of Engineers that he did that to qualify for a hog building distance. The producer testified, and you can tell by me using the word testified what happened here. The producer testified, no, I was going to do it anyway, and I had done it before I decided to put the hog building in to just clean up the place, to improve the farm. Army Corps of Engineers and the federal EPA claim, and this case hasn't been decided yet, that by doing that work on that ditch, that was a water of the United States, and that he had, under Section 404 of the Clean Water Act, had done the dredge and fill, and they're trying to find that producer for doing that work to a water of the U.S. The producer claims it was not a water of the U.S., that it doesn't qualify, and we all know all about the definition as water of the U.S. My point to you is, if you're siting hog buildings and there's a ditch there, be very careful about, make sure that it doesn't qualify as a water of the U.S., or you could have Army Corps of Engineers on your back. Okay, how are we doing here? Oh, 2 minutes. Okay.
I'm in the back giving you the 2 minutes.
I'm sorry, I can't see that. Okay. There's a little discussion Jamie and I have had here about this time thing, and I'll not lobby. Jamie, I'm not lobbying. Okay. Let's see. Animal capacity, how to figure it, and make sure you stay under your capacities. I'm going to leave that to your reading on the slides. Sorry I didn't get to that. I've talked about it in previous years. Calculate it. Make sure you stay under your capacities. Common ownership or management. I know I just moved right through those. I'm in slide 34. We could spend the next half hour talking about this, whether buildings are under common ownership or management, if they're within the adjacency distance of each other, and can you have buildings side by side owned by different people, father, daughter, father, son, mother. All I can do is explain the law to you and give you advice, and I'd like to do that individually instead of in a seminar. Get good advice on this before you move forward. Again, those are the factors DNR looks at. I've talked about those before. Here's one, and I'll end with this. I think the rest of them are pretty well self-explanatory. Slide 37. Question I got the other day. I think some of you MMP planners have dealt with this. You have an existing operation, 2,400 head. What's the distance to the neighbor's house if it was built after March of 2003? 1,250 feet, right? Let's say it meets that, but they want to add a second building to make it a 4,800 head site. Once you go above the 2,500 head, the distance to the neighbor's house is 1,875 feet, right? Okay, the 2,400 head building, let's say it meets the 1,250 but not the 1,875. Does that mean you can't expand? No. It means that if you add that second building, it has to be 1,875 feet away. The first building that was built there when it was a 2,400 head site is fine. Now, there's some county, there's been a lot of discussion. I got this call just last week, and I put the law up there. I think it's clear, and I've never had an issue with DNR on it, but you use, the last bullet point is the one you should look at for the example I just gave. You measure from the building that's being built, not the one that's already there. If the one that was there met the 1,250, you're fine. If the one you're building on that same site meets the 1,875, then you're okay under that section down there. If you have any questions about that, I'll be glad to visit with you. I think I'll stop right there. You're welcome to look at the rest of the slides. I know you'll read them in detail. You're welcome to give me a call. Thanks for coming this morning. I know it wasn't easy for some of you to get here and enjoy Port Congress, and guess hopefully we'll see you here next year. Thank you.